Labor Code of the Philippines as amended. Top 50 provisions of the Labor Code, which are the frequent sources of bar examination questions for the past 30 years. This simple presentation is not only for law students, but also to those who want to be familiar with important labor code provisions. This one is a bit boring.
Article 278. Strikes, picketing, and lockouts. A. It is the policy of the state to encourage free trade unionism and free collective bargaining. B. Workers shall have the right to engage in concerted activities for purposes of collective bargaining or for their mutual benefit and protection. The right of legitimate labor organizations to strike and picket and of employers to lock out, consistent with the national interest, shall continue to be recognized and respected. C. In cases of bargaining deadlocks, the duly certified and recognized bargaining agent may file a notice of strike or the employer may file a notice of lockout with the ministry at least 30 days before the intended date thereof. In cases of unfair labor practice, the period of notice shall be 15 days, and in the absence of a duly certified and recognized bargaining agent, the notice of strike may be filed by any legitimate labor organization in behalf of its members. However, in case of dismissal from employment of union officers duly elected in accordance with the union constitution and bylaws, which may constitute union busting where the existence of the union is threatened, the 15-day cooling off period shall not apply and the union may take action immediately. D. The notice must be in accordance with the implementing rules and regulations as the Minister of Labor and Employment may promulgate. E. During the cooling off period, it shall be the duty of the ministry to exert all efforts at mediation and conciliation to effect voluntary settlement. Should the dispute remain unsettled until the lapse of the requisite number of days from the mandatory filling of the notice, the labor union may strike or the employer may declare a lockout. F. A decision to declare a strike must be approved by a majority of the total union membership in the bargaining unit concerned, obtained by secret ballot in meetings or referenda called for that purpose. A decision to declare a lockout must be approved by a majority of the board of directors of the corporation or association or of the partners in a partnership, obtained by secret ballot in a meeting called for that purpose. The decision shall be valid for the duration of the dispute based on substantially the same grounds considered when the strike or lockout vote was taken. The ministry may at its own initiative or upon the request of any affected party, supervise the conduct of the secret balloting. In every case, the union, or the employer shall furnish the ministry the results of the voting at least 7 days before the intended strike or lockout, subject to the cooling off period herein provided. G. When, in his opinion, there exists a labor dispute causing or likely to cause a strike or lockout in an industry indispensable to the national interest, the Secretary of Labor and Employment may assume jurisdiction over the dispute and decide it or certify the same to the Commission for compulsory arbitration. Such assumption or certification shall have the effect of automatically enjoining the intended or impending strike or lockout as specified in the assumption or certification order. One has already taken place at the time of assumption or certification, all strike or disputes adversely affecting the continued operation of such hospitals, clinics, or going notwithstanding, the President of the Philippines shall not be precluded from determining representation issue in organized establishments. In organization of the freedom period, the employer shall continue to recognize the majority status means the tripartite voluntary arbitration advisory council established under exact and conditions of employment. Legitimate labor organization means any labor maintaining, changing, or arranging the terms and conditions of employment, regardless of official that may be authorized by the Secretary of Labor and Employment to act as voluntary violence, coercion, threats, or intimidation. Any peaceful picketing affecting wages, strike or lockout shall be declared after assumption of jurisdiction by the President or the Minister. Exercise of the right to self-organization or collective bargaining, or shall aid or abet. No person engaged in picketing shall commit any act of violence, coercion, or intimidation to initiate, dominate, assist, or otherwise interfere with the formation or to dismiss, discharge or otherwise prejudice or discriminate against. 229. Appeal. Decisions, award in case of a judgment involving a monetary award, an appeal by the employer may be perfected. The Commission shall decide all cases within 20 calendar days. For Secretary of Labor and Employment may, by appropriate regulations, restrict Article 107. Indirect employer. The provision commission of a crime or offense by the employee against the person of his employer or any immediate. Article 298. Closure of establishment and reduction. Article 295. Regular and casual employment. Article 124. Standards/criteria for minimum wage to induce industries to invest in the countryside. Improvements in standards of industries, provinces, or localities if in the judgment of the regional board, condition shall be mandatory for the NLRC to conduct continuous hearings and decide the dispute with workers paid by result, including those who are paid on piecework. TACA includes any individual employed by an employer. Agriculture includes fair and reasonable value, as determined by the Secretary of Labor and Employment, subject to the constitutional right of workers to security of tenure and their right to be protected. A Secretary of the Department of Labor and Employment may suspend the effects of the termination pending. The amount of subsidy in appropriate cases shall be determined by the board in accordance with establishments where no legitimate labor organization exists. Labor Management Committees. On expiration of the corresponding period, a certification stating why a decision or shall be entitled to full and detailed reports from their officers and representatives of all. Any action involving the funds of the organization shall prescribe after 3 in a written resolution duly authorized by a majority of all the members at a general membership once a year within 30 days after the close of its fiscal year. No special assessment or other extraordinary fees may be levied upon the members of a labor or the duty of any labor organization and its officers to inform its members on the provisions of it. Article 224. Jurisdiction of the labor arbiters. 5. Cases arising from any violation of Article 264 of this code, including questions involving the legality of strikes and lockouts, and 6. Accept claims for employees' compensation, Social Security, Medicare, and maternity benefits, all other claims arising from employer-employee relations, including those of persons in domestic or household service, involving an amount exceeding 5,000 pesos, P5,000.00, regardless of whether accompanied with a claim for reinstatement. The Commission shall have exclusive appellate jurisdiction over all cases decided by labor arbiters. See cases arising from the interpretation or implementation of collective bargaining agreements, and those arising from the interpretation or enforcement of company personnel policies shall be disposed of by the labor arbiter by referring the same to the grievance machinery and voluntary arbitration as may be provided in said agreements. Article 264. Duty to bargain collectively when there exists a collective bargaining agreement. When there is a collective bargaining agreement, the duty to bargain collectively shall also mean that neither party shall terminate nor modify such agreement during its lifetime. However, either party can serve a written notice to terminate or modify the agreement at least 60 days prior to its expiration date. It shall be the duty of both parties to keep the status quo and to continue in full force and effect the terms and conditions of the existing agreement during the 60-day period and/or until a new agreement is reached by the parties. Article 38. Illegal recruitment. Any recruitment activities, including the prohibited practices enumerated under Article 34 of this code, to be undertaken by non-licensees or non-holders of authority, shall be deemed illegal and punishable under Article 39 of this code. The Department of Labor and Employment or any law enforcement officer may initiate complaints under this article. Illegal recruitment when committed by a syndicate or in large scale shall be considered an offense involving economic sabotage and shall be penalized in accordance with Article 39 hereof. Illegal recruitment is deemed committed by a syndicate if carried out by a group of three or more persons conspiring and/or confederating with one another in carrying out any unlawful or illegal transaction, enterprise, or scheme defined under the first paragraph hereof. Illegal recruitment is deemed committed in large scale if committed against three or more persons individually or as a group. The Secretary of Labor and Employment or his duly authorized representatives shall have the power to cause the arrest and detention of such non-licensee or non-holder of authority if after investigation it is determined that his activities constitute a danger to national security and public order or will lead to further exploitation of job seekers. The Secretary shall order the search of the office or premises and seizure of documents, paraphernalia, properties, and other implements used in illegal recruitment activities and the closure of companies, establishments and entities found to be engaged in the recruitment of workers for overseas employment, without having been licensed or authorized to do so. Article 4. Construction in favor of labor. All doubts in the implementation and interpretation of the provisions of this code, including its implementing rules and regulations, shall be resolved in favor of labor. Article 129. Recovery of wages, simple money claims and other benefits. Upon complaint of any interested party, the Regional Director of the Department of Labor and Employment or any of the duly authorized hearing officers of the Department is empowered, through summary proceeding and after due notice, to hear and decide any matter involving the recovery of wages and other monetary claims and benefits, including legal interest, owing to an employee or person employed in domestic or household service or house helper under this code, arising from employer-employee relations. Provided that such complaint does not include a claim for reinstatement, provided further, that the aggregate money claims of each employee or house helper does not exceed 5,000 pesos, P5,000.00. The Regional Director or Hearing Officer shall decide or resolve the complaint within 30 calendar days from the date of the filing of the same. Any sum thus recovered on behalf of any employee or house helper pursuant to this article shall be held in a special deposit account by, and shall be paid on order of, the Secretary of Labor and Employment or the Regional Director directly to the employee or house helper concerned. Any such sum not paid to the employee or house helper because he cannot be located after diligent and reasonable effort to locate him within a period of 3 years, shall be held as a special fund of the Department of Labor and Employment to be used exclusively for the amelioration and benefit of workers. Decision or resolution of the Regional Director or Hearing Officer pursuant to this provision may be appealed on the same grounds provided in Article 223 of this code, within 5 calendar days from receipt of a copy of said decision or resolution, to the National Labor Relations Commission, which shall resolve the appeal within 10 calendar days from the submission of the last pleading required or allowed under its rules. The Secretary of Labor and Employment or his duly authorized representative may supervise the payment of unpaid wages and other monetary claims and benefits, including legal interest, found owing to any employee or house helper under this code. Article 110. Worker preference in case of bankruptcy. In the event of bankruptcy or liquidation of an employer's business, his workers shall enjoy first preference as regards their wages and other monetary claims, any provisions of law to the contrary notwithstanding. Such unpaid wages and monetary claims shall be paid in full before claims of the government and other creditors may be paid. Article 255. Ineligibility of managerial employees to join any labor organization, right of supervisory employees. Managerial employees are not eligible to join, assist, or form any labor organization. Supervisory employees shall not be eligible for membership in a labor organization of the rank and file employees but may join, assist, or form separate labor organizations of their own. Article 253. Coverage and employees' right to self-organization. All persons employed in commercial, industrial, and agricultural enterprises and in religious, charitable, medical, or educational institutions, whether operating for profit or not, shall have the right to self-organization and to form, join, or assist labor organizations of their own choosing for purposes of collective bargaining. Ambulant, intermittent and itinerant workers, self-employed people, rural workers, and those without any definite employers may form labor organizations for their mutual aid and protection. Article 269. Petitions in unorganized establishments. In any establishment where there is no certified bargaining agent, a certification election shall automatically be conducted by the Met Arbiter upon the filing of a petition by a legitimate labor organization. Article 228. Appearances and fees. Non-lawyers may appear before the Commission or any labor arbiter only if they represent themselves, or if they represent their organization or members thereof. No attorney's fees, negotiation fees, or similar charges of any kind arising from any collective bargaining agreement shall be imposed on any individual member of the contracting union, provided, however, that attorney's fees may be charged against union funds in an amount to be agreed upon by the parties. Any contract, agreement, or arrangement of any sort to the contrary shall be null and void. 275. Jurisdiction over other labor disputes. The voluntary arbitrator or panel of voluntary arbitrators, upon agreement of the parties, shall also hear and decide all other labor disputes including unfair labor practices and bargaining deadlocks. Article 295. Regular and casual employment. The provisions of written agreement to the contrary notwithstanding and regardless of the oral agreement of the parties, an employment shall be deemed to be regular where the employee has been engaged to perform activities which are usually necessary or desirable in the usual business or trade of the employer, except where the employment has been fixed for a specific project or undertaking the completion or termination of which has been determined at the time of the engagement of the employee, or where the work or service to be performed is seasonal in nature and the employment is for the duration of the season. An employment shall be deemed to be casual if it is not covered by the preceding paragraph, provided that any employee who has rendered at least 1 year of service, whether such service is continuous or broken, shall be considered a regular employee with respect to the activity in which he is employed, and his employment shall continue while such activity exists. 299. Disease as ground for termination. An employer may terminate the services of an employee who has been found to be suffering from any disease and whose continued employment is prohibited by law or is prejudicial to his health as well as to the health of his co-employees, provided that he is paid separation pay equivalent to at least one month salary or to one half month salary for every year of service, whichever is greater, a fraction of at least six months being considered as one whole year. Article 296. Probationary employment. Probationary employment shall not exceed six months from the date the employee started working, unless it is covered by an apprenticeship agreement stipulating a longer period. The services of an employee who has been engaged on a probationary basis may be terminated for a just cause or when he fails to qualify as a regular employee in accordance with reasonable standards made known by the employer to the employee at the time of his engagement. An employee who is allowed to work after a probationary period shall be considered a regular employee. Article 302. Retirement. Any employee may be retired upon reaching the retirement age established in the collective bargaining agreement or other applicable employment contract. In case of retirement, the employee shall be entitled to receive such retirement benefits as he may have earned under existing laws and any collective bargaining agreement and other agreements, provided, however, that an employee's retirement benefits under any collective bargaining and other agreements shall not be less than those provided therein. In the absence of a retirement plan or agreement providing for retirement benefits of employees in the establishment, an employee upon reaching the age of 60 years or more, but not beyond 65 years, which is hereby declared the compulsory retirement age, who has served at least 5 years in the said establishment, may retire and shall be entitled to retirement pay equivalent to at least one half month salary for every year of service, a fraction of at least six months being considered as one whole year. Unless the parties provide for broader inclusions, the term one half month salary shall mean 15 days plus 1/12 of the 13th month pay and the cash equivalent of not more than 5 days of service incentive leaves. retail, service and agricultural establishments or operations employing not more than 10 employees or workers are exempted from the coverage of this provision. Violation of this provision is hereby declared unlawful and subject to the penal provisions under Article 288 of this Code. Article 110. Worker preference in case of bankruptcy. In the event of bankruptcy or liquidation of an employer's business, his workers shall enjoy first preference as regards their wages and other monetary claims, any provisions of law to the contrary notwithstanding. Such unpaid wages and monetary claims shall be paid in full before claims of the government and other creditors may be paid. Article 82. Coverage. The provisions of this title shall apply to employees in all establishments and undertakings whether for profit or not, but not to government employees, managerial employees, field personnel, members of the family of the employer who are dependent on him for support, domestic helpers, persons in the personal service of another, and workers who are paid by results as determined by the Secretary of Labor in appropriate regulations. As used herein, managerial employees refer to those whose primary duty consists of the management of the establishment in which they are employed or of a department or subdivision thereof, and to other officers or members of the managerial staff. Field personnel shall refer to non-agricultural employees who regularly perform their duties away from the principal place of business or branch office of the employer and whose actual hours of work in the field cannot be determined with reasonable certainty. 88. Undertime not offset by overtime. Undertime work on any particular day shall not be offset by overtime work on any other day. Permission given to the employee to go on leave on some other day of the week shall not exempt the employer from paying the additional compensation required in this chapter. Article 128. Visitorial and enforcement power. The Secretary of Labor and Employment or his duly authorized representatives, including labor regulation officers, shall have access to employers' records and premises at any time of the day or night whenever work is being undertaken therein, and the right to copy therefrom, to question any employee and investigate any fact, condition, or matter which may be necessary to determine violations or which may aid in the enforcement of this code and of any labor law, wage order or rules and regulations issued pursuant thereto. Notwithstanding the provisions of Articles 129 and 217 of this code to the contrary, and in cases where the relationship of employer-employee still exists, the Secretary of Labor and Employment or his duly authorized representatives shall have the power to issue compliance orders to give effect to the labor standards provisions of this code and other labor legislation based on the findings of labor employment and enforcement officers or industrial safety engineers made in the course of inspection. The Secretary or his duly authorized representatives shall issue writs of execution to the appropriate authority for the enforcement of their orders, except in cases where the employer contests the findings of the labor employment and enforcement officer and raises issues supported by documentary proofs which were not considered in the course of inspection. An order issued by the duly authorized representative of the Secretary of Labor and Employment under this article may be appealed to the latter. In case said order involves a monetary award, an appeal by the employer may be perfected only upon the posting of a cash or surety bond issued by a reputable bonding company duly accredited by the Secretary of Labor and Employment in the amount equivalent to the monetary award in the order appealed from. The Secretary of Labor and Employment may likewise order stoppage of work or suspension of operations of any unit or department of an establishment when non-compliance with the law or implementing rules and regulations poses grave and imminent danger to the health and safety of workers in the workplace. Within 24 hours, a hearing shall be conducted to determine whether an order for the stoppage of work or suspension of operations shall be lifted or not. In case the violation is attributable to the fault of the employer, he shall pay the employees concerned their salaries or wages during the period of such stoppage of work or suspension of operation. It shall be unlawful for any person or entity to obstruct, impede, delay or otherwise render ineffective the orders of the Secretary of Labor and Employment or his duly authorized representatives issued pursuant to the authority granted under this article, and no inferior court or entity shall issue temporary or permanent injunction or restraining order or otherwise assume jurisdiction over any case involving the enforcement orders issued in accordance with this article. Government employee found guilty of violation of, or abuse of authority, under this article shall, after appropriate administrative investigation, be subject to summary dismissal from the service. The Secretary of Labor and Employment may, by appropriate regulations, require employers to keep and maintain such employment records as may be necessary in aid of his visitorial and enforcement powers under this code. Article 136. Classification of certain women workers. Any woman who is permitted or suffered to work, with or without compensation, in any nightclub, cocktail lounge, massage clinic, bar, or similar establishments under the effective control or supervision of the employer for a substantial period of time as determined by the Secretary of Labor and Employment, shall be considered as an employee of such establishment for purposes of labor and social legislation. Article 263. Meaning of duty to bargain collectively. The duty to bargain collectively means the performance of a mutual obligation to meet and convene promptly and expeditiously in good faith for the purpose of negotiating an agreement with respect to wages, hours of work and all other terms and conditions of employment, including proposals for adjusting any grievances or questions arising under such agreement, and executing a contract incorporating such agreements if requested by either party, but such duty does not compel any party to agree to a proposal or to make any concession. Article 258. Concept of unfair labor practice and procedure for prosecution thereof. Unfair labor practices violate the constitutional right of workers and employees to self-organization, are inimical to the legitimate interests of both labor and management, including their right to bargain collectively and otherwise deal with each other in an atmosphere of freedom and mutual respect, disrupt industrial peace and hinder the promotion of healthy and stable labor management relations. Unfair labor practices are not only violations of the civil rights of both labor and management but are also criminal offenses against the state, which shall be subject to prosecution and punishment as herein provided. Subject to the exercise by the President or by the Secretary of Labor and Employment of the powers vested in them by Articles 263 and 264 of this Code, the civil aspects of all cases involving unfair labor practices, which may include claims for actual, moral, exemplary, and other forms of damages, attorney's fees and other affirmative relief, shall be under the jurisdiction of the labor arbiters. The labor arbiters shall give utmost priority to the hearing and resolution of all cases involving unfair labor practices. They shall resolve such cases within 30 calendar days from the time they are submitted for decision. Recovery of civil liability in the administrative proceedings shall bar recovery under the Civil Code. No criminal prosecution under this title may be instituted without a final judgment finding that an unfair labor practice was committed, having been first obtained in the preceding paragraph. During the pendency of such administrative proceeding, the running of the period of prescription of the criminal offense herein penalized shall be considered interrupted, provided, however, that the final judgment in the administrative proceedings shall not be binding in the criminal case nor be considered as evidence of guilt but merely as proof of compliance of the requirements therein set forth. Article 218. Declaration of Policy. It is the policy of the state to promote and emphasize the primacy of free collective bargaining and negotiations, including voluntary arbitration, mediation, and conciliation, as modes of settling labor or industrial disputes. To promote free trade unionism as an instrument for the enhancement of democracy and the promotion of social justice and development. To foster the free and voluntary organization of a strong and united labor movement. To promote the enlightenment of workers concerning their rights and obligations as union members and as employees. To provide an adequate administrative machinery for the expeditious settlement of labor or industrial disputes. To ensure a stable but dynamic and just industrial peace, and to ensure the participation of workers in decision and policy-making processes affecting their rights, duties, and welfare. To encourage a truly democratic method of regulating the relations between the employers and employees by means of agreements freely entered into through collective bargaining, no court or administrative agency or official shall have the power to set or fix wages, rates of pay, hours of work or other terms and conditions of employment, except as otherwise provided under this code. Article 267. Exclusive bargaining representation and workers' participation in policy and decision-making. The labor organization designated or selected by the majority of the employees in an appropriate collective bargaining unit shall be the exclusive representative of the employees in such unit for the purpose of collective bargaining. However, an individual employee or group of employees shall have the right at any time to present grievances to their employer. Any provision of law to the contrary notwithstanding, workers shall have the right, subject to such rules and regulations as the Secretary of Labor and Employment may promulgate, to participate in policy and decision-making processes of the establishment where they are employed insofar as said processes will directly affect their rights, benefits, and welfare. For this purpose, workers and employers may form labor management councils, provided that the representatives of the workers in such labor management councils shall be elected by at least the majority of all employees in said establishment. Article 266. Injunction prohibited. No temporary or permanent injunction or restraining order in any case involving or growing out of labor disputes shall be issued by any court or other entity, except as otherwise provided in Articles 218 and 264 of this code. Article 274. Jurisdiction of voluntary arbitrators or panel of voluntary arbitrators. The voluntary arbitrator or panel of voluntary arbitrators shall have original and exclusive jurisdiction to hear and decide all unresolved grievances arising from the interpretation or implementation of the collective bargaining agreement and those arising from the interpretation or enforcement of company personnel policies referred to in the immediately preceding article. Accordingly, violations of a collective bargaining agreement, except those which are gross in character, shall no longer be treated as unfair labor practice and shall be resolved as grievances under the collective bargaining agreement. For purposes of this article, gross violations of collective bargaining agreement shall mean flagrant and/or malicious refusal to comply with the economic provisions of such agreement. The Commission, its regional offices and the regional directors of the Department of Labor and Employment shall not entertain disputes, grievances or matters under the exclusive and original jurisdiction of the voluntary arbitrator or panel of voluntary arbitrators and shall immediately dispose and refer the same to the grievance machinery or voluntary arbitration provided in the collective bargaining agreement. Describe Article 155. Regulation of industrial homeworkers. The employment of industrial homeworkers and field personnel shall be regulated by the government through the appropriate regulations issued by the Secretary of Labor and Employment to ensure the general welfare and protection of homeworkers and field personnel and the industries employing them. Article 134. Stipulation against marriage. It shall be unlawful for an employer to require as a condition of employment or continuation of employment that a woman employee shall not get married, or to stipulate expressly or tacitly that upon getting married, a woman employee shall be deemed resigned or separated, or to actually dismiss, discharge, discriminate or otherwise prejudice a woman employee merely by reason of her marriage. Article 111. Attorney's fees. In cases of unlawful withholding of wages, the culpable party may be assessed attorney's fees equivalent to 10% of the amount of wages recovered. It shall be unlawful for any person to demand or accept, in any judicial or administrative proceedings for the recovery of wages, attorney's fees which exceed 10% of the amount of wages recovered. Article 94. Right to holiday pay. Every worker shall be paid his regular daily wage during regular holidays, except in retail and service establishments regularly employing less than 10 workers. The employer may require an employee to work on any holiday, but such employee shall be paid a compensation equivalent to twice his regular rate, and, as used in this article, holiday includes New Year's Day, Maundy Thursday, Good Friday, the 9th of April, the 1st of May, the 12th of June, the 4th of July, the 30th of November, the 25th and 30th of December, and the day designated by law for holding a general election. Article 95. Right to service incentive leave. Every employee who has rendered at least 1 year of service shall be entitled to a yearly service incentive leave of 5 days with pay. This provision shall not apply to those who are already enjoying the benefit herein provided, those enjoying vacation leave with pay of at least 5 days, and those employed in establishments regularly employing less than 10 employees, or in establishments exempted from granting this benefit by the Secretary of Labor and Employment after considering the viability or financial condition of such establishment. The grant of benefit in excess of that provided herein shall not be made a subject of arbitration or any court or administrative action. Article 137. Minimum employable age. No child below 15 years of age shall be employed, except when he works directly under the sole responsibility of his parents or guardian, and his employment does not in any way interfere with his schooling. Any person between 15 and 18 years of age may be employed for such number of hours and such periods of the day as determined by the Secretary of Labor and Employment in appropriate regulations. The foregoing provisions shall in no case allow the employment of a person below 18 years of age in an undertaking which is hazardous or deleterious in nature as determined by the Secretary of Labor and Employment. Article 233. Compromise agreements. Any compromise settlement, including those involving labor standard laws, voluntarily agreed upon by the parties with the assistance of the Bureau or the Regional Office of the Department of Labor, shall be final and binding upon the parties. The National Labor Relations Commission or any court shall not assume jurisdiction over issues involved therein except in case of non-compliance thereof, or if there is prima facie evidence that the settlement was obtained through fraud, misrepresentation, or coercion. Article 289. Visitorial power. The Secretary of Labor and Employment or his duly authorized representative is hereby empowered to inquire into the financial activities of legitimate labor organizations upon the filing of a complaint under oath and duly supported by the written consent of at least 20% of the total membership of the labor organization concerned, and to examine their books of accounts and other records to determine compliance or non-compliance with the law and to prosecute any violations of the law and the Union Constitution and bylaws, provided that such inquiry or examination shall not be conducted during the 60-day freedom period nor within the 30 days immediately preceding the date of election of Union officials. 227. Technical rules not binding and prior resort to amicable settlement. In any proceeding before the Commission or any of the labor arbiters, the rules of evidence prevailing in courts of law or equity shall not be controlling, and it is the spirit and intention of this code that the Commission and its members and the labor arbiters shall use every and all reasonable means to ascertain the facts in each case speedily and objectively and without regard to technicalities of law or procedure, all in the interest of due process. In any proceeding before the Commission or any labor arbiter, the parties may be represented by legal counsel, but it shall be the duty of the chairman, any presiding commissioner or any labor arbiter to exercise complete control of the proceedings at all stages.
Wow, butit nakarating kayo dito. Tsinagaan nyo talaga. Good luck on your studies. Please subscribe to Bob Research and like Labor Cases Dole and LRC Tulungan Facebook page. Kuya Bob also interacts with his group mates at the Labor Cases Dole and LRC Tulungan Facebook group.